Justice De Castro.
Let's go back to the duty of the conscientious objector to refer.
Yes, Justice.
Which you are discussing a while ago with Justice Abad. What is the compelling state interest in imposing this duty to refer to a conscientious objector which refuses to do so because of his religious belief? What is the interest?
Your Honor,
what is the compelling state interest to impose this burden?
In the first place, Your Honor, I don't believe that the standard is a compelling state interest. This is an ordinary health legislation involving professionals. This is not a free speech matter or a pure free exercise matter. This is a regulation by the state of the relationship between medical doctors and their patients.
But,
we cannot impose the highest possible standard, because the highest possible standard in constitutional law is limited only to the relationship between the state and citizens.
If it is not the highest standard, there must be some standard that will show that the action
Yes, Your Honor, rational basis standard.
That this provision is not arbitrary. So what is the rational basis to impose this duty to refer, which will impair the religious freedom of the conscientious objector?
Again, Your Honor, number one, thank you for accepting the rational basis standard. The rational basis standard
I'm not
is...
accepting that. I just want you to explain your position.
Okay. I think, Your Honor, that the rational basis standard is complied with when the state decides to say that Filipinos who are poor are allowed to have access to RH information and services. The law is right-creating in that sense. It creates access to Filipinos who have the right but who don't have the choice because of their economic challenges. And I think, Your Honor, that is a rational relationship. We are providing you with this right, and this right is impaired if a doctor who is a professional refuses to perform his or her professional functions.
It's not the performance of the professional function of the doctor. It is simply referring that person whom he refused to take in as a patient to another health service provider. That is not an exercise of his professional duties as a doctor.
Yes, Your Honor, that is because the government already excuses the doctor from performing his or her medical function. This is already a compromise. When the government says you have the duty to refer, what the government is saying is, we are allowing you already to be unprofessional by not performing your function. But you can't be a bad person and totally refuse access to RH services and information of a citizen. You cannot transform the citizen who needs access to RH information and service into a victim.
All right. Your position is that that is a responsibility of a doctor, which you should justify on the basis of a code of professional conduct of doctors. That if he does not want to perform something, he has to refer that patient to another person, to another doctor. I don't see any obligation on the part of a doctor to find someone else or another doctor for that patient whom he refuses to take in as a patient.
Yes, thank you, Madam Justice De Castro.
Yes.
The original obligation is the duty to perform or provide RH service and information. That is the original obligation of the medical professional. And the medical professional, because he or she is a conscientious objector, is allowed already by the state not to perform that original function. This is a highly reduced function. This is a minimal burden. So the state is saying, if you're not going to act professionally by not providing the RH information or service that everyone else is required to do or perform, we will impose on you a minimal burden. You're going to refer. Because otherwise, Your Honor, to not refer would be to create a victim in the form of that patient. That would be equivalent to the case of Ebralinag, someone who does not salute the flag or sing the national anthem, but disrupts the entire proceedings. So what the state is saying is, you are allowed to remain silent, but you cannot transform yourself into a positive impediment in the implementation of a health law.
Isn't information dissemination of government programs the responsibility of government and not any individual or any professional? if there is a program like this, family planning program on the part of government, isn't it the concern of the government to see to it that information is disseminated by
Absolutely,
government?
Your Honor. And
why-
so
why
the government
impose-
here
why
acts through the doctors,
But why
the
impose-
medical professionals.
Yeah, why impose that on someone when that will go against his religious belief?
Because
When
that
he has
someone,
no
Your Honor,
obligation
is
to-
a public official, is a doctor who wears a hat saying that I am willing to treat anyone and everyone.
What we're talking about here is information dissemination. And so, isn't it, what I'm asking you is, I want you to explain why
Yes, Your Honor.
the dissemination of information on family planning should be imposed on a person, a doctor, who believes that this will go against his religious belief.
Yes.
This is a clash between compulsion being made by the government, however light it is, which may impair the religious freedom of a doctor.
I think,
That-
Your
that-
Honor,
you have to justify
Yes, Your Honor.
why
Thank
it
you.
should be the obligation of
yes.
the doctor
And
to
the
do
justification, Madam Justice De Castro, is this. I think the theory of the statute is that a big part of the inability of Filipino citizens to maintain their reproductive health is a consequence of lack of information. And this lack of information has a big social impact. And this lack of information is also the result of certain structural injustices in our society. People don't have the money to spend on internet so they can Google the latest information on RH. What the government does is simply providing the bureaucratic mechanism, right, so that the information which is not available to a lot of Filipinos, women, children, and males, right, will finally become available. And information that they can also totally reject. And the only way to do that, Your Honor, is through the public, the Department of Health, through its control over public hospitals and to a certain extent, private hospitals.
So you believe doctors should to keep themselves abreast of what health service provider or health service professionals are available to whom they can go to? Is that the responsibility of every doctor now to see to it that they know where to refer these persons, even if this will go against their religious belief? Are you not imposing, is the law not imposing this undue burden?
I don't think it is an undue burden, Your Honor, because, again, it arises not in the
that
context
will
of...
an undue burden which a person may think to have that tendency to impair his exercise of religious freedom.
Yes, Your Honor, I am a lawyer, and therefore I don't have a duty to provide RH information and service. I can go against the RH law all the time. But if I am a doctor, I am bound by certain duties. And what the government is doing here is regulating that particular duty, the duty between the doctor and a patient. And I think there is a clearly rational relationship between the right of the state to regulate that duty insofar as ensuring that those who don't have access to information will be on a position of parity with those who actually have access because they have the money to access the information.
But look at these cases which may involve which are not emergency in nature, not emergency cases. So time is not of the essence. So if someone approach a doctor and would like to know about family planning method, the information need not be given right then and there because this is not an emergency situation unless he wants to have to do the sexual act right after leaving the doctor's clinic. There's no such emergency situation that will compel the physician to exercise his professional duty, if you consider that a duty.
I think, Your Honor, what the statute does is to allow citizens to have access to information
Yes,
and
but that
services,
is, as
whether
I
or not
said-
it's
as
on
I
an
said-
emergency basis.
As I said, isn't that a responsibility of the government to disseminate information.
And the information, Your Honor, is being disseminated by the government through the DOH, through its hospitals, and through people who work in those public hospitals, such as doctors, nurses, midwives.
Shouldn't that be enough?
That's exactly, Your
Instead
Honor, what
of,
the government is doing.
Instead of imposing a burden which will impair the exercise of religious freedom of a physician?
No, Your Honor, because if you are a public health service provider, right, you are within that governmental framework, within the bureaucracy, you assume certain responsibilities, and those responsibilities are professional responsibilities. Here, the law is already very reasonable in the sense that it respects the right of a conscientious objector not to perform that professional function. But there is a minimal burden. That minimal burden is the obligation to refer. Because otherwise, Your Honor, you are creating a victim out of a patient. A victim who spent, the only money he or she has to go to a healthcare center, right?
Isn't this like the minimal burden of saluting the flag
No.
for a few minutes when the flag, when the national anthem is being played?
In Ebralina, Your Honor, the court actually allowed the Jehovah's Witnesses to be excused. But that burden is a burden imposed on a citizen. This is a special kind of burden. This burden arises in the context of a professional relationship. Again, Your Honor, just like in the case of Judge Veneracion, even if he were a true Catholic, true to the ideology of his beliefs, right, he is required by the Supreme Court to impose the proper sanction. What the court is saying is, regardless of your faith-based epistemologies, right, you have to perform a certain function. This is a professional duty for you.
That's different. The law imposing the death penalty has not the constitutionality of that law has not been questioned. But now we are evaluating the constitutionality of this provision of law. So we're trying to see if this will be able to surmount the constitutional objection on the ground of impairment of the freedom of religion.
Your Honor, I'm
situation
sorry
is
to
different.
disagree.
The situation is different.
The situation is different because in the case of Judge Veneracion, he actually has a stronger case. In the case of Judge Veneracion, he could have very well said, I'm being used as an instrument to kill someone by imposing the penalty myself. Here, the burden is right, simply to refer.
He has a
If we're looking for an analogy, I would say the case of Judge Veneracion for an exemption is even stronger because he's the one who's imposing the penalty himself. Here, assuming that we believe the faith claims of the religious, it's actually a lesser burden because the duty is simply to refer, not to kill.
The difference is very marked because the law there has not been questioned. The law must be applied as it is written. Since the constitutionality of the law involved in that case has not been questioned. But here, we are in a different situation. We're trying to find out if this law, which some would consider to be an impairment of the exercise of the freedom of religion, will not be considered a violation of the Constitution.
Yes, Your Honor.
There is no analogy between these two situations.
Your
All right,
Honor,
now
I think the religious is entitled to a full exemption in terms of conscientiously objecting and not being able to refer. If the assumption of our free exercise jurisprudence is that the state will entitle the believer to a full exemption. But that has never been the case. I remember Justice Bernabe asking Attorney Liban, Your Honor, is there a difference between the right to believe and the right to act on one's belief? And Attorney Liban says yes. The right to believe is absolute, but the right to act on one's belief is subject to regulation. Here, what is being regulated is not simply the right to act on one's belief, but the right to act on one's belief in the context of a professional duty. And I think that's a very powerful distinction, Your Honor.
Since the law does not make a distinction between a doctor in a public institution and a doctor exercising his profession in private, I think you should be able to justify why you will apply the same standard for both doctors.
Because the
One
duty
in
to
public
provide
and the other in
access to
private
RH
practice.
services information, when it arises in the context of a doctor-patient relationship, doesn't require the existence of a
why the
public
doctor
duty or a
should
private
assume-
duty.
Why the doctor should assume a burden which is reposed on the government, which is disseminating information about its family planning program to the extent that it may impair the exercise of freedom of religion.
Your Honor,
I'm
yes.
I don't like to argue anymore with you. I raised this question for you to be able to explain this, no, in
Yes,
your
Your Honor.
memorandum.
Thank you, Your Honor. We will
Because,
explain it in our
because,
memorandum.
that's how I look at it. It seems to be that the government is imposing the burden of disseminating information on doctors, whether they are in public or private health institutions. And what can be the justification for that? To the extent that that it may impair the religious belief of a doctor who is not in a public or government hospital or institution.
Yes, Your Honor. But if I may just give you a short answer, a doctor who works in the private sphere has the full constitutional right under the statute to conscientiously object. And so that doctor doesn't have the obligation to provide RH information and service if he or she objects. The limited burden is to refer, if that doctor-patient relationship arises at all. But we will provide you with an extended articulation in our memorandum,
You should
Your Honor.
address the position
Yes, Your
of the
Honor.
petitioner, one of the petitioners, that even just referring to another health service provider will already be an impairment of their religious belief, because
Yes.
it will require them to do an act which they consider to be sinful.
Yes, Your Honor.
Go now to the penal sanction for intentionally giving incorrect information.
Yes.
Will you tell us the elements of this offense? It is important for the law to be clear about the elements of the offense. Otherwise, this may not pass muster a constitutional objection.
Okay. Your Honor, the elements of the offense from the statute text itself would be, number one, you are a healthcare service provider as defined under the RH law. Number two, you knowingly withhold information or restrict dissemination of that information. And number three, and or intentionally provide incorrect information regarding RH, regarding programs and services on RH.
From this language of the law, will you be able to know what is information that cannot be withheld and what is incorrect information that cannot be given?
Well, I can speculate on a factual situation for you, Your Honor. Someone
But
goes to a...
you cannot go into a factual situation. We are looking at the language of the law.
Okay, Your Honor.
The elements of the crime, or
Yes.
any offense, must be found in the law.
Yes,
not
Your
in
Honor,
the
I agree.
application, not in the application of the law. How can you apply the law when the law is not clear? So you have to explain to us the meaning
Yes.
or the elements of the offense here. The elements, what is meant by information, what is meant by incorrect information for one to be liable under this law.
Okay. I would suppose, Your Honor, that what is meant by information under the statute would be information regarding RH programs and services, including reproductive health, including the right to informed choice and access to full range of legal, medically safe, non-abortive, efficient, and effective family planning methods.
Information to be found.
In Section 1, Your Honor. In paragraph 1, item 1 of Section 23,
But
paragraph A, number 1.
You're referring to principles. I'm referring to the actual source of the
The
programs and the services.
The actual source, Your Honor, is Section 23, paragraph A, number 1.
Information coming from the FDA.
No, Your Honor. to provide incorrect information regarding programs and services on reproductive health, including the right to informed choice and access to a full range of legal, medically safe, non-abortifacient, and effective family planning methods.
Where can a person find this information?
The full range, Your Honor, would be in the definition of the statute.
To provide this information.
It's in the statute, Your Honor.
Statute, but you are referring to programs and services. A party must know what information is referred to in this provision of law. The actual information that he is withholding, or information which is he is misrepresenting, disseminating.
Again, Your Honor, I don't get your question.
Is this, okay, I'll go direct to the point.
Okay.
Are you referring to the government sanctioned or approved information? Information about the safety of contraceptives and any other device may vary. The scientific studies may vary. And so there may not be any consensus or unanimity on the safety of a particular contraceptive device or pill.
Well, in that
So,
case, Your Honor, no one would be prosecuted because the element of the law is knowingly withholding information and providing incorrect information. If the debate is still robust, then it would be difficult to provide incorrect information because there's still a wide expanse of opinions with respect to the correctness or incorrectness of a particular information. I think, Your Honor, this would refer to settled information.
Information provided by the FDA, that was what was mentioned here in the previous oral arguments, that the FDA will be the authoritative source of what is safe, and that is what is found in the law. It is the FDA that will say that.
Yes, Your Honor.
Because it will procure contraceptive pills and devices, and therefore the FDA will be the one to decide which is safe.
Yes, Your Honor, because it is the government institution with the technical expertise to make judgments on that matter.
So any information that will go against what the FDA has declared will be a violation of...
I don't think any information. I think the gist of the statute is becoming a positive hindrance to the full access to RH information or service of a citizen. I think that is the gist of the statute. If a doctor gets in the way of that access by providing intentionally incorrect information, I think the government has the right to penalize anyone who performs one's professional duty maliciously. I think it is in that context, Your Honor, that the statute was passed. Not in the context of any other theoretical or academic disagreement on RH matters.
It does not say malicious, it says intentional. What if the doctor intentionally give a different information because that is what his experience and his training and education has taught him?
Yes, Your Honor, an important and an integral element of the statute is knowingly withholding, providing incorrect information. There has to be knowledge.
It's knowledge that the knowledge which may be considered incorrect because it goes against the information given by the FDA. It doesn't have to be malicious. The doctor may not be in bad faith. He may be honestly exercising his professional judgment that what the FDA said is, or what the FDA prescribed is not correct.
I would disagree, Your Honor. Intentionally providing incorrect information. You have to know the correct information for you to be able to know what is incorrect information. And you decided to provide intentionally and knowingly that incorrect information. You have two spheres of knowledge, correct knowledge, incorrect knowledge. You chose knowingly incorrect knowledge, and you provided that knowledge to someone. and therefore impairing that person's right to informed choice and access to RH services and information. I think, Your Honor, that's a legitimate subject matter for a penal sanction.
Place. Someone must decide what is correct and incorrect.
At some
So
point,
will-
of course, yes, Your Honor, someone will have to
Yes,
decide
so
in the same way that the court will have...
Under the law, it's the FDA that will decide what is correct and incorrect. And so there is
Yes, Your
there
Honor.
can be no dissent.
And
under
I have
under
no-
the law, there can be no dissent, and any dissent will be penalized as a crime.
Under the law, Your Honor, I have no problem with the FDA providing me with the standardized information with respect to the safety of certain drugs. Why? Because I'm a lawyer, not a doctor. I don't have the technical expertise to disagree with the FDA on these matters. And the judgment of the FDA when it comes to what is safe and what is not safe is very important, because anyone who provides incorrect information may harm that patient.
The information here does not contemplate
What the statute provides,
an
Your Honor...
information coming from a lawyer. The information here is coming from a healthcare service provider. So
Exactly, Your Honor.
Don't use yourself as an example, because precisely...
Sorry, Your Honor. Here, what is covered by the situation is the situation of someone who is in a position to know because of his or her medical training, and yet, because of that position to know, still decides to provide the incorrect information knowingly.
But
I think that is a...
Yes, but going through scientific studies, we have found varying views about the safety of certain contraceptive and
Yes, Your Honor,
other devices.
and we have done the same research, but we would always... I think, Your Honor, it's good policy to be very cautious when it comes to
My only point-
entering the realm of a different discipline.
My only point here is that I want to find out if the law defines precisely the elements of the offense.
Yes,
because
Your
that
Honor.
is important for this to be considered as constitutional, because it gives adequate information on one who is accused of violating the provision of the law. So that is the only reason why I'm
Yes,
asking this
yes.
question from
Okay.
you. I want to know what is correct and what is incorrect information, and to find out from you whether the language of the law is sufficient enough to inform whoever is accused that he has violated the provision of the law.
Yes, Your Honor.
That is just what
If I may, Your Honor,
that
I'd
is
like
just-
to
yes, that
to
is just
provide
what
two
I wanted to
answers. Number one, the first answer is that this particular provision of the statute cannot be subjected to a facial challenge precisely because it doesn't have any speech component. The other answer, Your Honor, is that the statute is complete and clear because generally what it does is to penalize a professional who, knowing the correct information, decides to withhold or provide the incorrect information to the possible detriment or injury of a citizen, someone who relies on that information.
If there is no speech component, what conduct is being penalized by this provision?
The
of law?
conduct of withholding information or providing incorrect information.
Isn't that
Not all information, Your Honor, is speech under the Constitution. This is not political speech, Your Honor. If this were political speech, if I were talking to a friend, and that friend gave me incorrect information about the standards of the FDA, can I prosecute that person under this statute? No. Maybe under some provision or under the tort system, yes. But here, Your Honor, this is speech in the context of the medical field. Not all types of information are free speech or can be subjected to the test of freedom of speech. That speech will have to be in a particular forum, a public forum. That speech will have to be the kind of speech that should be subjected to the freedom of the market. Medical knowledge, Your Honor, is a highly constrained information environment. You don't just say anything just because you want to act like a doctor. Doctors are highly trained, just like lawyers. They have full control over the jargon, and that jargon can be used to the detriment of the person. The general thrust of the statute is you cannot use your medical knowledge to create a victim out of an innocent patient. And I think, Your Honor, the statute is legitimate when it does that.
What is being put in issue here is the precise precise information that this provision of law gives to anyone who will stand accused of
Yes, sir.
violating this provision of law, whether or not the language as written is enough to inform the accused of what he is being
Yes,
charged
Your Honor.
with.
And
Now,
our answer, Your Honor,
do you agree that compelled information is the antithesis of informed consent? Because the information here is being compelled. So no
I
other
don't think
dissent
so, Your
or
Honor.
no other information can be given
Your
by
Honor,
a doctor. Because here the government compels, there is a compulsion as to the information that doctors and health service providers will give to a patient. And therefore, this will go against informed consent. The patient is not given a full picture. There is only information coming from one side, information coming from the government. So no doctor, no health service provider can speak against it.
if
So
I may,
is that
Your Honor,
is that informed consent?
if I may, Your Honor, the government does not have the right to tell me as a citizen whether or not Marxism or libertarianism is correct. But the government certainly has the right to compel doctors to comply with the standards of their discipline. Whether or not antibiotics work one way or another cannot be subjected to free speech, Your Honor, because that discipline is a highly constrained discipline. They can determine whether or not which standards of practice is violate or are violative of the standards of their profession. This is not a matter of political theory. This is not a free speech matter, Your Honor. This is a matter that can affect the health of a citizen who doesn't
Precisely.
know any better.
We are past the issue of free speech. We're now
Okay.
in the issue of informed consent.
Okay.
So so don't digress. Don't digress from the issue at hand. What you're being asked is whether or not the compelled information coming from the government is not contrary to the informed consent that is needed to protect the health of a mother.
Your Honor, if someone doesn't agree with what the government is saying, the standards of the FDA, right, all that medical practitioner will have to do would be to raise his or her conscientious objector status and refer that patient to another person. That is the reasonable, in fact, the rational way for that doctor. What the statute is saying, you cannot use your standing, your position as a medical doctor who has the authority, some level of authority over a patient, and maliciously use that to provide incorrect information on the patient, because that information may be used to the detriment of a patient.
Don't inject the term malicious. We're not talking about malice here. We're talking about correct or accurate information.
Your Honor,
We did
knowingly
not be- excuse me.
withholding.
Yeah,
Sorry, Your Honor.
willingly withholding or intentionally giving incorrect information. Intentional is different from malicious. As a lawyer, you know that. These are two different things. I may intentionally tell you this because I believe that this is correct. But you cannot say that I'm doing it in bad faith. That is a state of mind. Intention is different from malice. So let's not confuse the two terms.
Okay.
All right. Now,
If I'm... okay.
so we're no longer, we're talking about informed consent. And that is
Okay.
what I'm asking you. Now, if a doctor sincerely believes that what was provided by the government is not safe, is it ethical for that doctor to still let someone to go to another doctor who will prescribe that medication which he believes is harmful to the health of that woman? Is that what you want that doctor to do? You want the doctor to refer, just like a conscientious religious objector. If he believes that is wrong, that is morally wrong, or if the doctor believes that is scientifically wrong or unsafe, you want that doctor to still refer that patient to another who will prescribe the same medication which he believes to be unsafe?
Your
Why
Honor,
will you, is that not unethical? Is that a violation
if I
of
may,
the
Your Honor,
code of conduct of a
I
doctor?
wouldn't want my doctor to exercise his profession on the basis of belief. I would want my doctor to exercise his profession on the basis of knowledge.
Don't mislead. We are not talking about a doctor prescribing something which is based on his religious belief. That's another matter. What I'm saying, I'm just making an analogy.
You're referring to ethical beliefs, Your Honor.
I'm referring to an analogy that between these two situations, a conscientious objector who believes that it will be against his religious
Then that is a
conviction.
conscientious objector
Yes,
on
that
the
is
basis
different.
of...
That's different. What
Okay.
we're talking about now is a doctor. A doctor, based on his experience, based on his extensive experience and his knowledge that he acquired by conscientious study and training, if he believes that a device or a contraceptive pill that is being disseminated by the government is harmful, you want this doctor to still refer that person, that patient, to another who will prescribe the same medicine or device which he considers to be unsafe? You think that is right for him to do?
Your Honor, a doctor who, based on his medical experience, believes that the government institution, with all its expertise, is wrong, is not necessarily right. Just because you believe that the government information that hormonal contraceptives, a particular type of hormonal contraceptive is safe, doesn't make you right. And so the compromise is, if you have an ethical objection with respect to the use of a certain RH supply or certain RH information, then don't be tyrannized by your own belief. You have the duty to refer. I think that's a good compromise, Your Honor.
Even if it goes against the professional judgment of a doctor, I'm referring here to the free exercise of a doctor, of his profession, the use of his professional judgment. Just like us lawyers, we have different ways of looking at things. And
Yes, Your Honor.
a doctor may have a different diagnosis of a patient who may...
Yes, Your Honor, but...
because you cannot apply the same medication
Yes.
to everyone. Every person will have a different psychological,
Yes, Your Honor,
physiological,
but just
or
like
physical makeup.
just like lawyers, Your Honor, who
Yes.
will have to comply with the existing jurisprudence of the Honorable Court with respect to how to file an appeal, what kinds of petition, the periods for complying with certain requirements, medical doctors will also have to comply with the minimum standards of their profession.
The rulemaking is the concern of the court. The court set precedents. The court set the rules for court procedure. But so what we're trying to find out is a similar authoritative source or agency which can really provide unquestionable guidelines as to what is safe and what is good for each and every person. So
That, Your Honor, would be the FDA. If it's the Supreme Court in the case of the reading of the Constitution, interpretation of statutes, creation of rules, the analogous institution, I would suppose, would be the FDA, because the FDA is statutorily charged and has the institutional expertise to determine what is safe. And we have to rely on that expertise because there's no other institution we can rely on. At some point, we have to rely, in the same way that at some point we have to rely on the decisions of the Supreme Court.
and the exercise of the practice of medicine is very different from the practice of law. There are marked differences between the two, and scientific studies may contradict each other, and there may be no one that can really choose which between the conflicting scientific studies or opinion is correct.
Then in that case, Your Honor, a particular accused would not be convicted. Because if the information is, the debate is still robust, then you cannot charge that person with knowingly providing incorrect information. Because for you to be able to charge and convict someone with knowingly providing incorrect information, that person must first and foremost know what is the correct information. And if, based on your example, the information can go either way, there's still a debate, then there's no way you can charge and convict someone with knowingly providing incorrect information.
Go either way, but the FDA may have that authority to say, this, we choose this side, we choose this opinion, and that is it. There will be no dissent.
Again,
that
Your Honor,
we
cannot test the constitutionality of the statute on the assumption that government institutions will act unprofessionally or go beyond or even against the bound and duty of these institutions.
That's not the point. We're still, what I'm trying to point out only is that you should be able to show to us that the information mentioned here is enough to apprise an accused of the nature of his violation. Because the law does not say what is this information that should be considered correct or incorrect.
Your Honor, I would suppose that the ultimate test for determining the content of the statute, whether or not it's vague enough, would be in an as-applied challenge. When you have a real accused who has the interest in defending himself or herself, that is the time for us to determine whether or not the law is actually vague.
Right, but you need to point out the
yes,
elements,
Your Honor. Definitely, we will do that in our memorandum.
No, I'm not arguing with you. I just want you to bring
yes, Your Honor.
out
Thank you,
these
Your Honor.
issues in
Yes.
your memorandum. Now, what about the requirement that there should be a certificate of compliance
Okay.
that a couple went through before they can be given a marriage license?
Yes, Your Honor.
Is this not a burden imposed on, an undue burden imposed on couples who would like to marry? What is the state interest here that is being served by requiring this certificate of compliance?
Your Honor, I think the state interest is clear to provide information, again, which may be rejected by the prospective couples on matters involving responsible parenthood, family planning, breastfeeding, and infant nutrition. I think the understanding, Your Honor, is that some Filipino couples or prospective couples go into marriage with little or insufficient or even incorrect information about responsible parenthood, family planning, breastfeeding, and nutrition. This is a rather benevolent government program to try to provide them with the opportunity to learn about the burdens of parenthood. And this opportunity is in the form of an information which, again, they can totally reject. And so I think, Your Honor, this is a very reasonable mechanism.
But they are compelled to go through this process before they can be issued a marriage license.
Yes, Your Honor.
Is
But
this an imposition on the exercise of the right to marry?
no, Your Honor, because this is not a substantive qualifier. Right? It's not like an age requirement or a property requirement that goes into the right of a person to marry. This is an administrative requirement, Your Honor. And there's a reasonable relationship between this administrative requirement and the interest of the state in ensuring that prospective spouses, future families of the Republic will have an opportunity to acquire sufficient information on responsible parenthood, family planning, breastfeeding, and infant nutrition. Again, Your Honor, bottom line is if they want to reject this information, they can totally reject it.
Now, why is it that the consent of the husband is not needed where one would like to avail of the family planning methods provided by the government?
No, Your Honor, I think that applies to procedures, not information. I suppose, Your Honor, you are referring to Section 23, paragraph 2I of the statute, which prohibits the refusal to perform legal and medical safe reproductive health procedures and the spousal consent requirement in the case of married person. What the statute is simply saying, Your Honor, is that at the private level, spouses can agree on who has the authority to have a legal and medically safe reproductive health procedure. But the level of the statute, in case of disagreement, the decision of the one, whether the male or the female, the husband of the wife, or the wife undergoing the procedure shall prevail. It simply recognizes the right of the individual to some form of sovereignty over the bodily integrity of that person, whether it's the male or the female.
Don't you think procreation is equally the concern of the husband and the wife? And this will be more inconsistent with the constitutional principle about the value of the family, value of marriage and the family?
I think, Your Honor, that is one view that can be held by a citizen. It is within the range of legitimate constitutional concerns. But if there's a couple out there who believes that they don't want to have children, then they are constitutionally entitled to that opinion as well. But if a couple believes that procreation is the primary goal of their relationship, then they can actually do that here, Your Honor.
The consent of either one of the spouses is not necessary if one would like to
in case of
avail
disagreement.
The reproductive health procedures?
No, Your Honor, because I think this is simply a constitutional recognition of the right to liberty of a person, whether the husband or the wife, to his or her bodily integrity. Marriage doesn't give you the right to transform your spouse, whether the husband or the wife, into an instrument for procreation. I think that's the basic rule. This will have to be done at the level of consent. If both of you believe that you should have a no vasectomy or a no ligation policy, the Constitution respects that, Your Honor. You can have as many children as you want. You can, frolic like rabbits if you want. But the law says, in case of disagreement, if there's a disagreement between the husband and the wife, with respect to legal and medically safe reproductive health procedures, then it is the person whose body is concerned that will have the choice. And I think, Your Honor, that is a reasonable statute.
That's the second part of the provision. But
Yes,
the
Your
first
Honor.
part would mean that one can keep it a secret from his or her spouse if he wants to have this reproductive health procedure. That is the main idea here. It is the sole decision of one of the spouses to avail of these reproductive health procedures secretly without the knowledge of the husband or the wife.
I wouldn't couch it in those terms.
Yeah,
I think the statute allows it, but that is not the main thrust of the law.
That's the first part. The last part is only refers to a disagreement.
Yes,
and there
Your
will
Honor.
be no disagreement if this is kept secret from the other spouse.
Your Honor,
these are
yes.
two different situations. One, the availment of the reproductive health procedure is kept secret, and that is allowed by law because the law says that a doctor cannot refuse because the other party or the husband or the wife has not given his or her consent to this procedure.
Okay.
So it's keeping it secret. Do you think that is consistent with the constitutional provision about marriage and raising a family?
Your Honor, I think keeping it secret is something that is allowed by the law, but that is not the thrust of the law. The thrust of the law is basically a non-discrimination norm. What it says is a healthcare service provider, whether public or private, who shall refuse to perform legal and medically safe reproductive health procedures on a person of legal age on the ground of lack of consent or authorization of the following persons. Spousal consent in the case of married persons. That means, Your Honor, simply that a public health care provider who can perform this legal and medical safe procedure cannot require of that person authorization from the spouse. That is simply what it means.
Which effectively would allow that spouse to keep it secret.
It allows the spouse to keep it secret, but that is not the main thrust of the statute. It is an option available, right, for that spouse to do it. If it's the husband who wants to have ligation without the knowledge or consent of the wife, then that can be done.
This is like
But that is not the thrust.
This is like a double-edged sword. When you see one side, but you fail to see the implication. That will be the implication of this provision of law.
I think, Your Honor, that the goal of the law is to respect the privacy of the spouses. That in a wide range of factual situations, the husband or the wife who wants to have a safe and medically safe procedure will inform the other spouse. But there's no compulsory system for that in this case, because the Constitution simply respects the privacy rights of the spouses to determine the kind of relationship they want to have. If the relationship between the spouses is healthy, I would assume, Your Honor, that the husband or the spouse who will have the vasectomy or ligation will inform the other spouse out of respect, out of a sense of obligation or duty. But the law covers a bottom line situation where if the spouse concerned doesn't want to inform, or if she informed or he informed the spouse and that spouse disagrees, then the law steps in and says, it's your body, you have the right to undergo that safe and legal and medically safe reproductive health procedure. I think that is reasonable, Your Honor.
This principle is found in other legal systems where a full autonomy or full control and disposition over one's body is allowed. Now, what I want to find out is how you would relate this to the provisions of the Constitution on marriage and family, whether keeping secret a matter of procreation to a matter which affects procreation from the other spouse can be considered constitutionally infirm or constitutionally valid. You deal with that. I can understand why. What is the basis for this provision? Because I've read this in other articles.
Yes, Your
Honor. Where they do not have a similar. The legal system is different from ours.
Yes, Your Honor.
They have a different constitution, but our constitution is very detailed.
Yes, Your Honor.
Touches on so many subjects.
Yes, Your Honor.
And we cannot just import ideas from other legal system without taking into account our constitutional principles.
Yes, Your Honor.
So
I think, Your Honor, if I may.
I just want to find out. I'm not trying to argue with you.
Yes, Your Honor. Thank
I'm just breaking your imagination and pointing
Your
out
Honor.
to you what are these issues that are bugging me and which I want you to explain in your
Yes.
memorandum.
Yes, Your Honor.
Because if I write my opinion on this and without giving you the opportunity to express
Yes.
is your refutation of that
Yes, Your Honor.
position.
If I may, Your Honor, just articulate, I think, the theory behind the statute. The basic idea, I think, is the assumption that the state cannot compel spouses to have healthy relationships. It's up for these spouses in the private realm to develop a working relationship. And so almost all the time, right, most of the time, the state actually respects that kind of a relationship. But in case of a conflict, Your Honor, this is a conflict situation where there's a disagreement with respect to access to legal and medically safe reproductive health procedure. What the law says is we will respect the right of the person who is undergoing that procedure, whether it is the husband or the wife, right, to have that procedure. Why? Because it is his or her body. It is a gender-neutral statute that simply respects the right of a person to bodily integrity. And I think, Your Honor, that is rather reasonable.
You're on the second part of the law, that provision of law. I'm referring to the first part about the secrecy of undergoing this health procedure. And so you cannot go to that realm of disagreement, because how can someone disagree with something which he or she does not know?
I would
So
assume, Your Honor.
That's the.
Yes, if I may
I
respond.
have no problem about
Yes.
disagreement.
Yes.
The provision that I want you to explain is that provision which will allow one of the spouses to keep secret from the other spouse that he will undergo a medical procedure
Yes.
that will prevent
Your Honor, if I may,
pregnancy.
I think the thrust of the
between
statute.
spouses if a woman takes contraceptives without informing the husband, that is a sign of
Your Honor, that is
dishonesty.
not-
That is not good.
That is
for
not
the
covered by
relationship.
this particular provision, because this provision covers legal and medically safe reproductive health procedures. And I think this particularly refers to vasectomy and ligation. The thrust of the law is not to promote a culture of secrecy, but to disable a public service provider from requiring an authorization prior to performing legal and medically safe reproductive health procedure. It doesn't have anything, Your Honor, to do with the use of contraceptives, because this particular provision refers to legal and medically safe reproductive health procedures. And I was informed that this refers to...
That is a way not to keep the other party uninformed about what's going on. That is the provision that will excuse a party from securing authorization or consent from the other party, will enable that party who wants to avail of this procedure to keep it a secret from his or her spouse.
It's an option, Your Honor, that is available.
That is the effect.
I wouldn't say it is
the
the
implication.
intended effect, Your Honor. I would say it is an option available because the government basically respects the privacy right of the spouses to what? The legal and medically safe reproductive health procedure. If a spouse wants to keep this secret, the government is not making any moral judgment on the health or the quality of that relationship. It's only looking at whether or not that spouse, whether the wife or the husband, has that particular right. And the government's answer is yes. On the ground that authorization requirement is not allowed under the statute.
I said we should gauge this on the basis of the provisions of the Constitution.
Yes, Your Honor, we will do that in our memorandum. Thank you, Your Honor. Yes.